Good afternoon. Welcome on in to another episode of From Day One. This afternoon, we're going to go to Judge Stevens' courtroom as we have a pro se attorney that could be potentially looking at life in prison.
Under probation, not on community supervision.
See, this is
That's
the
fine, I'm
problem.
sorry.
This is the problem here when you represent yourself and you say what you know what you're doing.
Oh, they're changing,
This
it's
is,
changed.
no, ma'am. Deferred or unadjudicated probation is a form of. Katrina Davis, are we ready on Miss Davis's case? Thank you. We're working on the hard copies. Kind of like in the old days here, and then this will be scanned in to the records.
Tell 'em you're-
35837 is now called the state of Texas versus Katrina Davis. The defendant is present. You are going to represent yourself.
Yes, sir.
All right. And the state's attorney is present. Now, for the record, set forth your experience and training in law that, and you are an attorney at law here, and you're licensed in the state of Texas.
Yes, I am.
And if you would be so kind to just give a summary of your experience with law.
I do business law.
Ma'am,
I handle business law. I am an instructor for the state bar. I am on
what?
for this for business law. I am one of the panelists for 2020, so qualified to be able to discuss business law in regards to the annual meeting at 11 point. I have practiced for the last 7 years and have clients both civil and have handled criminal cases with Brennan Dunn. I have handled criminal cases with Brennan Dunn as one of his assistants. Like that.
What have you done in those? Have you handled felonies as well as misdemeanors?
He did do a felony
Okay.
case, yes.
Numerous?
No,
Okay.
I did one with him only.
Okay. Was that a trial?
It was.
Okay, so you sat in the
Okay.
trial and went
Yeah.
through the trial?
Yes.
Are you
And,
sure you want to do this?
Anything else to add as to your experience and training under law?
Or lack thereof?
No,
All right, or do you understand, you certainly have a right for your own attorney if you wish.
yes.
Are you willing and exercising your right to represent yourself pro se? Are you doing that voluntarily, knowingly, intelligently?
I
And
doubt on
is
that last
that
one,
what
Your Honor.
you insist on doing
The
here?
intelligently part.
Yes. I thought
Go
we
ahead.
did that. I thought we had did that already.
We're putting it on the record during the plea hearing so that
Okay.
we know as you're about to enter the plea hearing, you haven't changed your mind on anything you may have said in the past.
We
No,
know that you're still an
This is
idiot.
what you insist on doing,
yes.
representing yourself. In summary,
That's what you want.
and do you agree we can proceed in summary?
Yes.
In summary, this indictment alleges that on or about September 24th, 2020, in Jefferson County, Texas, you committed the first-degree felony of aggravated assault on a public servant. Do you understand what is
Oh.
alleged here, ma'am?
Yes, that I committed, allegedly committed, I guess.
A crime.
Aggravated assault on a public servant, as it is alleged in this indictment.
Probably beating up a police officer.
If convicted, this is a first-degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. The court decides that there is no fine here. Is there any restitution?
No, yeah.
There is no restitution. So the normal and customary terms for this type of offense under probation would be carried into play and would be part of the order of probation. Is that your understanding?
I object to pleading guilty.
Mm.
I'm sorry, what you said?
I object to pleading guilty. Is there no contest available under the deferred?
That wasn't my offer, Chip. And she's already signed the admonishment.
Okay, well, you can't just surprise us here. I mean, that was, we don't, you don't drop that sort of thing on everybody. I guess you can insist on pleading no contest, but what does the state say? This is supposed to be a plea agreement between the parties. Are you saying that
May I see
is
the
not you?
admonishment?
And
Okay, how
yeah,
do you plead to this? Guilty or not guilty or no contest? Okay. Do you understand a plea of no contest or nolo contendere?
Yes.
In Latin,
yep, no look contendere, Your Honor. You got it.
has the same effect, a knowingly and intelligently made plea of no contest, has the same effect as a plea of guilty, although it may not be used as an admission of liability in any civil cases. Do you understand?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, knowingly, and intelligently? Did you understand its contents? And is everything true and correct there?
Everything is true and correct, and I did knowingly intelligently sign the stipulation waivers and judicial admissions.
No.
And then if found guilty, if convicted, first degree felony, 5 to 10 years. I seen there was a signature from the side, so I didn't know that was.
God, you're an idiot. You could be life in jail, in prison.
State's Exhibit 1 is tendered into evidence. Any objection? No objection. Without objection, it's admitted. That you are mentally competent to enter your guilty plea, which is freely and voluntarily made.
Yes.
You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with your method of representing yourself pro se in these proceedings. You understand you have a right to have your own independent attorney as legal counsel. You are waiving that and making that decision voluntarily, knowingly, intelligently. All of this, it states, is true, so help you God. Is that so?
I thought that it was not guilt until after, the admission of guilt is not found until after the deferred adjudication.
Oh, fuck.
No, there is enough evidence here from this admission here
That you
to find you
made,
guilty
that
beyond
you're
a
guilty.
reasonable doubt.
Okay.
But I am deferring any finding of guilt so long as you follow the terms and conditions of probation.
Which is whatever.
You're going to go in front of the probation office. You read those.
Oh, wait,
Go.
I'm confused. I don't want to do it. There's no probation. I don't want to do probation, I'm not supposed to keep community supervision.
See, this is
That's
the
fine,
problem.
I'm sorry.
This is the problem here when you represent yourself and you say what you know what you're doing.
Oh, they're changing.
This is, no, ma'am. Deferred or unadjudicated probation is a form of probation. Probation is a generic term. We use that generically in the practice of law. It is community supervision formally, but is also referred to as probation, whether it's regular probation, which is where you're found guilty and your sentence of imprisonment or confinement is suspended so long as you follow the terms and conditions of probation, or deferred or unadjudicated probation, where there is no finding of guilt so long as you follow the terms and conditions of probation.
Okay.
See, that's another problem we have here when you elect to represent yourself in a matter of law that you're not really familiar with, which you can do. And from time to time, individuals do that, but generally they're not as trained in law as you are.
Absolutely, Your Honor. I just wanted to
Or
figure out what the
stupid.
terms were before I agree.
There they are. They're normal and customary in all cases.
Other words, stop being a
In
dumb
hours of
fuck.
community service restitution. I'm sorry, anger management, I'm not 17, this was just given to me, so that's why I'm not sure, and I don't think that's customary in every case.
Ma'am, when you're on
Anger
probation, you don't dictate the terms of your probation.
Yes.
Or judge.
Tell him, Your
I
Honor.
am pretty sure those terms,
Then this which is withdrawn, we will set this for trial. Thank you. That is all.
Mr. Laird is willing
Huh?
to try, Mr. Laird's willing to try that case for me.
Today?
Yes,
Okay.
both him and.
All right. Have a seat.
Mr. Duchesne.
All right. Who else is? Yes, buddy. Brenda.
Roderick James.
No, man, we're moving forward today.
Yeah, there is no plea.
You're going to prison today.
All right, back on Miss Davis.
yes,
Yes, sir.
We recall 235837 Katrina Davis. For all purposes. And again, do you waive a formal reading of this indictment? Can we proceed in summary once again?
yes,
In summary, this indictment alleges that on or about September 24th, 2020, in Jefferson County, Texas, you committed the first-degree felony of aggravated assault on a public servant, which
Probably a
carries
police
with it
officer.
a term, if convicted, of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you were charged with and the punishment range applicable?
yes,
An agreement has been reached where you would not be found guilty, but placed on deferred or unadjudicated probation, which can be up to 10 years in length, no fine. There will be terms and conditions of probation.
Really?
which,
You're going to give her another
will be
chance?
Prepared, the court
Judge?
will approve. These are normal and customary for this type of offense. Do you understand?
yes,
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
yes,
How do you plead to this offense charging you with the first-degree felony of aggravated assault on a public servant? Guilty, not guilty, or nolo contendere, no contest?
no contest,
Are you pleading no contest voluntarily, knowingly, intelligently? And do you understand the consequences of pleading no contest, which is a plea of no contest has the same effect as a plea of guilty, except it generally cannot be used in any civil actions brought forth from the facts of this case that you were pleading no contest to.
yes,
It is admitted. Stand down. Among other things, this states that you are mentally competent to enter your plea, which is freely and voluntarily made. You understand what you are charged with.
Being
The
stupid?
indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are getting it through your plea of no contest. You are giving up your rights of jury trial and the right of the appearance, confrontation, cross-examination. You were totally satisfied with the representation provided by yourself in this case, since you were self-represented. And you swear all of this is true, so help you God.
yes,
State's Exhibit 1 is made a part of the record for all purposes. Because this is no contest, the state has an opportunity to read into the record any additional evidence which supports the defendant's no contest plea, so that there is enough evidence presented for the court to find the defendant guilty and then defer those proceedings under this agreement. And you can but this is going to have to be later sworn to right here.
yes,
You can proffer the information.
Just a second.
There has to be an independent presentation. I don't, unless you want to Throw in the
According to
probable
the-
cause affidavit.
I'm gonna tender the information from the probable cause affidavit provided by Officer Trey Armstrong with Beaumont Police Department.
Okay, a
On-
copy of that can be made a part of the record. Is there any objection to it, ma'am?
I'm sorry, the police officer.
Yes.
I thought he was a fire marshal.
Well, whoever the person is who prepared, I'm presuming it was a
The victim
an
was,
officer of some sort, but anyway, here, this is it. Have you seen that?
Means-
He's gonna put that into evidence from the state's presentation, then you can make any objections or changes to it.
Object to a no.
Hmm?
I object to the wording of the statement denied.
Oh, dear God.
I have to swing of the knife.
Is that it? Is that all?
Yes, sir.
Okay, the rest of it. Without objection, except for that portion dealing with the knife, then it is made a part of the record as state's exhibit sticker. Please. Problem is, you're gonna have to add something else on your own unilaterally. Since that makes up an element of the offense, right? What it takes to make a first degree felony is the use of a deadly weapon. He's objecting to that portion of state's exhibit 1. She's pleaded no contest to this. There still has to be an independent presentation when there's not a plea of guilty. It's to support a no contest plea.
my position is that her objections are not lawful. She's given no grounds as to why she's objecting to those matters. This is a probable cause that has been a portion of the court's file. There's nothing more than a recitation of the facts, as well as the admissions that she's already made that are contained within the indictment, as well as State's Exhibit 1, which is the judicial confession.
Admissions.
What essentially what he's saying is really, you don't have to agree this is correct, but it is his proffer from the state's presentation that that's what he his evidence shows is true and correct in this. You can object, but otherwise that it's his presentation. This is what he is alleging. He is presenting as an independent presentation that his case would show, and you're objecting only to that portion dealing with a knife. Your objection is noted. It will be overruled. The state's exhibit 1 is admitted, and your objection to the use or presentation of a knife is going to be shown in the record that you differ on that, but yet you are pleading no contest to the indictment, which includes as an element that a deadly weapon, namely a large knife, was used.
Your Honor, with proper addition, there's a civilian witness by the name of Tasha Coleman who is on standby for the testimony in this trial. Her specific statement, as well as testimony that she would provide in trial, verifies that this individual began to swing a knife at the fire marshal, which is Terrence Simon. I'm quoting directly from her report. The state has that physical evidence in and would present it in trial. Officer Simon is available as well to testify about the knife that she is pointing at him. The officers that responded are, and additionally would testify in trial, are Officers Armstrong, Price, Roberts, Gilmore, and Leslie, that all had dealings with her that day, that also affirm those accusations that are subject to this conversation.
Okay,
I object again to Tasha's
okay,
statement.
yeah, just, all right.
So
You're allowed to introduce other documentation if you want to do that, to support that. That just. Are you objecting, or are you going to just not? Or are you intending, because I know your goal is to get the end accomplished, which is placing you on deferred or unadjudicated probation. But this step is, we're stumbling on this step. Are you insisting on objecting, or are you just going to stand mute? Once again,
I am.
Otherwise, he'll be entitled to present more evidence into the record. And that may or may not be what
Tendering a statement.
you feel is in your best interest in the end game of what you were trying to complete here. Because each element of the offense that constitutes the offense, there has to be some evidence to support it under a no contest plea.
So the statement that I saw, this wasn't in the record. This was in the record. So I will refer to the additional second page. The one page was the only thing that was in the record.
Yes, ma'am. Go ahead.
So let me look real fast.
Yes, ma'am.
What's the number we're at, Judge?
I'm sorry.
What exhibit number are we at?
I've got Courts Exhibit 1, which is the election to self-represent, and that's been admitted. You've got States Exhibit 1 is the only thing I have. Then we also have here, well, there's two States Exhibits. One, this is going to be number 2. States Exhibit 1 was part of the plea papers. We're going to call this
Let's make
States
that
Exhibit
3.
You want this 3?
Yes, sir, because States Exhibit 1 is the judicial admission. Court's admonishment as to,
It's courts
Courts
1.
so we've got States 1 should be the admonishment within the plea.
Where's States 2?
Let's make that States 3, which you have in your hand.
Okay.
This will make this
3
States 2.
is what's already been
She was-
introduced and admitted as States 1. We have corrected that to States 3 because States 1 is part of the plea papers that are already in evidence. So where's your States Exhibit 2?
States 2 is being
Tender,
reviewed by the defendant. It is a statement from Natasha Coleman.
Natasha Coleman identifies it as a spatula, not a knife. It's a spatula that she mentions. I still, object to the swinging. I object. She says spatula again. Let's see. If it was louder, she would have and I charged at her. I object to that. At no point did she say on the 911 call that I charged her. She said there were other people in the facility that possibly could have gotten charged with anything. I was walking around. That's when we saw right outside. When we saw a fire marshal truck pull up, that's when I asked him if I can get the police here sooner. We went back to his truck to make a call, and they came back inside the store. And I approached her. She began to swing the spatula at the fire. She wasn't there. There was no female standing there with me when I spoke to him. So I object to her statement, page 2. I object to the fact I do agree to the spatula that she mentions in her statement.
That still doesn't make the element of the offense, which is a deadly weapon was used, which she's pleading no contest to. The State's Exhibit 2 is also introduced into evidence, but it's objected to by the defense in her version. of the facts.
And the state's position is those are not legal objections. Those are her saying that something happened differently in an attempt to try to testify to the court.
I understand.
This-
I understand your
Yes, Your Honor.
objection. They're admitted
Thank you.
under the method of this plea. She's pleaded no contest. And understands what that means under the law. And that the elements have been supported by not only her plea, but states 2 and 3.
All right, so we're going to stop it there. Come on back for the evening to find out the conclusion, knife or spatula. And what's going to happen? This girl is trying to talk herself out of almost a sweetheart of a deal, considering where she could end up life in prison. We'll find out that tonight on here on From Day